Swayam Prabha. Digital India. Educated India.
Hello all. So moving forward, let's start our discussion regarding the IP licensing agreements and the Indian competition law. So in these modules, we will look into how the various IP licensing agreements are dealt by the Indian Competition Commission, and particularly with the illustrations of the case laws and the case analysis, we will look into this matter. So in this module, particularly we will deal with the nature of IP agreements and the various jurisdictions issues, like to understand like how the IP, like is the IP agreements are coming under the purview of competition law itself or not. And again, as I mentioned, we will look into different cases to understand how the cases has been resolved, or the jurisdictional issues as well as the licensing issues were resolved by the Competition Commission of the India. So, by far our so far by our discussion on the various provisions laid in the Indian Competition Act of 2002. So, we know by this time we know that the various agreements may be horizontal, vertical, the anti-competitive agreements, if it is having certain appreciable adverse effect on the competition in India, then it may be considered as an anti-competitive agreement. So, there are basically the licensing agreements can be a vertical agreement, which is covered by the subsection 4 of section 3, and where it provides that the enterprise operating in the upstream market, basically the licensor is licensing the intellectual property rights to another enterprise which is operating in a downstream market, which is the licensee. So, this is so they are at two different labels of the supply chain. So, this is a vertical agreement. So, it is one kind of licensing agreement that is possible, and it is also possible that there is some kinds of licensing agreement between the enterprises which are operating at the same level, the horizontal agreement. But again, for the consideration of the IP licensing, such agreements will also be perceived to be vertically related. That may happen, suppose if a company has certain procedure for packaging of certain material, and another company B is having a very advanced method for the packaging of the material. Since both of them are related to the packaging of the material, like they are in the same level, but anyway, since a licensing agreement is there related to an intellectual property right, for the purpose of this competition law, it will be considered as perceived as a vertical agreement. And when the licensor is having a dominant power, or is a dominant player by virtue of this market share or technology which it is having, then in that relevant market, then the competition assessment will be regarding its abuse of the dominance position. So, section 4 of this Competition Act particularly deals with the abuse of the dominant position. So, all this so far we have already seen and learnt. So, now we will look how the Indian Competition Act the provisions are laid, and how the Competition Commission of India is generally deals with such kind of issues. So, first, not all agreements are anti-competitive. An agreement will be considered as an anti-competitive agreement when it will have an appreciable adverse effect on the competition in India. So, the agreements falling under the subsection 3 of section 3 of this act, which particularly deals with the horizontal agreement including cartels, are presumed to be having an appreciable adverse effect on competition, or means are presumed to be per se anti-competitive. So, the per se rule is applied here, means any horizontal agreement per se may be considered as anti-competitive. Now, the vertical agreements which comes under the subsection 4 of section 3 of Indian Competition Act are dealt in a rule of reasoning basis, means the deeds or the nature of the agreement is looked into detail to understand whether there will be or whether it is causing or it may cause an appreciable adverse effect in the competition or in India or not. So, a rule of reasoning approach is the ROR analysis is done to understand whether the vertical agreements are anti-competitive or is anti-competitive or not. And also we have seen that the section 3 subsection 5 of section 3 has laid down the various acts or related to intellectual property which may be considered as an immune which may be which in certain cases may be considered immune from the provisions of the other sections as of section 3. So, basically the section subsection 1 of 3(5) of the Act specifically provides for an exemption for the agreements falling under the section subsection 3 and subsection 4 of section 3 of the Act. In that case, imposition of the reasonable restriction for the protection of intellectual property rights conferred under the various statutes like the Patent Act, Copyright Act, Trademark Act, Semiconductor and Integrated Circuit Chip Protection Act, then there is Geographical Indication and Protection Act. So, all these statutes are that can like to protect their right given by such statutes or such laws, reasonable restriction may be imposed and that will not come under the purview of the competition law. But for the conduct falling under the purview of the section 4 for possible abuse of dominant position, it is also tested on the basis of the rule of reason approach. It is not per se considered as an anti-competitive. The rule of reason analysis is followed to understand the nature anti-competitiveness of the agreement. Even though there are exemptions provided under the subsection 5 like section 3 subsection 5 of this Act, it does not directly is implied to section 4, means if certain if there is a dominant player which is having certain intellectual property rights and it is abusing its power dominance with respect to those intellectual property right, in those cases this subsection 3 subsection 5 will not come into the picture and it will be dealt only on the basis of the rule of reason approach. So, even like sometimes in many of these cases the IP holders consider that since all these reasonable restriction can be placed as per the section 3 subsection 5. So, they are immune from the competition law, but it is not this case. That is reasonable restriction only to protect the right conferred by the various IP laws to prevent the infringement of the right, but that does not mean that they can place any restriction to enjoy their right. Obviously, IPR is a monopolistic right. So, you are a IP holder is free from any obligation or he himself can enjoy the right the way he wants, but that does not mean he will place any kind of restriction that will lessen the competition or raise the price of the product or may give any anti-competitive feature in that agreement. So, before understanding how the IP cases are dealt under the competition law, first we have to understand the question, is IPR coming under the purview of the competition law? I am asking such question because many of these cases has landed in the general courts like the Supreme Court and the High Courts just to find out whether Competition Commission of India have the jurisdiction to analyze those cases or not. So, as I mentioned earlier, people or the IP holder generally think that we have a blanket exemption because we are having an IPR, a blanket exemption from the competition law, but no, this is not true. There is no blanket exemption provided to the IPRs when it comes under the purview of the Competition Commission of the India. So, the landmark decision in this case was the case between the Ericsson and the Competition Commission of the India. So, here in this case a petition was filed by Ericsson challenging the jurisdiction of the Competition Commission of the India with respect to the certain cases related to the patents. Basically, it was a case related to standard essential patents, but we will deal that details of this regarding the standard essential patents and technology in a later section. But here the petition was regarding the jurisdiction, whether the CCI is having a jurisdiction to determine the cases involving the patent right or standard essential patents, whether IP is coming under the purview of CCI or not. So, the assertion made by the Ericsson before the Delhi High Court was that the orders passed by the CCI were without jurisdiction, as the CCI lacked jurisdiction to commence any proceeding in relation to the claims or royalty by a proprietor of a patent, which is covered by the Patent Act of 1970. So, as per Ericsson, all the matters related to patents are covered by the Patent Act of 1970. The amount of royalty, how the royalty sharing will be will happen, what will be the condition, all should come under the purview of the Patent Act only. So, the Competition Commission of India does not have any jurisdiction for deciding or ordering any to pass any order related to its patent negotiation. But after considering all the facts and all these evidences and the nature of the remedies provided both in the Competition Act and the Intellectual Property like the Patent Acts of 1970, the Delhi High Court observed that if there are irreconcilable differences between the Patent Acts and the Competition Act, insofar as anti-abuse provisions are concerned, the Patents Act being a special act shall prevail. Means or the remedies between the Patent Act and the Competition Act is inseparable, that it is not it is very similar, then the Patent Act shall prevail. So, but they found that there is no irreconcilable difference between the two statutes, where there is no such differences between the two such statutes, and the remedies provided by the Competition Act of 2002 for abuse of dominant position were substantially different from the remedies available under the Patent Acts of 1970. There is no remedy for the abuse of dominant position in Patent Act of 1970, and the remedies available as per the Competition Act are completely different, and these are not mutually exclusive. That means, the grant of one remedy is not destructive of the other. Means, if you sought for one remedy, you can it is not that you cannot sought for the remedy under the Patent Act. These two remedies from these very two different acts are very different, and they are not mutually exclusive. So, finally, the Delhi High Court said that these decisions are non-overlapping decision. The prospective licensee may approach the controller of the patents under the Patent Act of 1970 for the grant of the compulsory license in certain cases. So, if there is if certain licensing negotiation fails, then we have the provision of the compulsory licensing under the Patents Act. So, the licensee may approach the controller general of patent for compulsory licensing, and it also may approach the Competition Commission of the India to get an appropriate order. Therefore, the application of this act to these cases involving IPR is not barred at all. Means, Competition Commission of India had the jurisdiction to solve or to issue order related to cases where intellectual property are involved. So, these cases, it has been like there are other cases also, but with these cases it has established that the subsection 5 of section 3 is not a blanket immunity. This provides the subsection 5 of section 3 of this act provides that section 3, which basically prohibits the agreement which has appreciable adverse effect on the Indian market, will not affect the right of any person to impose reasonable condition as may be necessary for protecting any of his rights. Like these are the reasonable restrictions, reasonable condition for protecting their rights, means protecting their rights from infringement. Therefore, IPR holder cannot impose any restriction as he wants to be. So, these restrictions should be reasonable, keeping in mind to just enjoy his rights from to prevent it from infringement. So, thus the licensor by the way of an agreement has imposed a reasonable restriction for protecting any of these rights recognized by any of the statutes mentioned in that section, and it will, and thus other provisions under the section 3 and under the provision of subsection 1 of subsection 1 and subsection 4 of the section 3 will not be applicable. So, the reasonable, for those reasonable restriction the anti-competitive provisions will not be applicable, but when it will be a abuse of dominant position, then obviously it will, the court it will look into the rule of reasoning approach and how it has caused the appreciable adverse effect in the environment in the competition market, that will be analyzed. So, again this misconception about the blanket immunity related to IP is also further dealt by also further like proved in another cases where the FICCI Multiplex Association of the India versus United Producer and Distributors Forum, UPDF in short form. So, this case is between the FICCI Multiplex Association of India. It has alleged that the United Producers and Distributor Forum, the Association of the Motion Pictures and the TV Program Producers, and the Film and Television Producers Guild of India, like all these three were behaving like a cartel. So, here again to establish, like as we have seen, the cartels are like, it is very difficult to get proof regarding the cartel and understand their how they are functioning underneath. So, it has also in his complaints stated that all these respondents, all these three parties, like they distribute almost 100% of the Hindi films produced, like they produce, they supply and they distribute the films in India, and thereby exercise almost complete control over the Indian film industry. Means these parties are also in a dominant position and they are behaving like a cartel. So, this complaint has gone to the Competition Commission of the India. So, the FICCI has alleged that the respondent, the UPDF, the United Producer and Distributors Forum, had issued a notice instructing all these members not to release any films to the member of the FICCI. So, what was happening, because all these are all producers association, they has sent notice to all these multiplexes theatres. Like multiplexes has become a new kind of where people can get themselves entertained with the cinemas. After the small cinema theatres, the multiplex culture has started in almost all parts of the India. So, during certain negotiation failure, after certain negotiation failure, the UPDF has asked all the multiplex theatres not to showcase any movie to this FICCI. Now, notice was also sent to the members by the UPDF, because the conflict between the producers and the distributors and the members, the basic conflict was between the FICCI Association of the Multiplex Association of the India and the UPDF. The basic point of difference was the royalties sharing, revenue sharing ratio. So, in earlier days, it has been alleged that in 2009, the producer and the distributors have started demanding unreasonable amount of royalty sharing. Earlier it was revenue sharing. Earlier, for a particular kind of film, they may charge around 40 to 44% of the revenue in the first week. Then in the subsequent weeks, the revenue sharing decreases like 30% or 35%. Again, it depends the nature of the movie, but in 2009 they demanded 50% of revenue sharing for all week. So because of this demand, there was certain conflict between the association of the multiplexes and between the this producers guild. So, from that the problem has started, and the FICCI alleged that the members of this UPDF who are the competitors and like they nearly control the 100% of the market for the production and the distribution of the Hindi films in the multiplexes. So, basically the multiplexes are the relevant market in this case, and they now all these parties in the respondents, they have come together and they are trying to fix the price, that the revenue sharing, and that is why they are behaving like a cartel and violating the subsection 3B of section 3 as per the Indian Competition Act. So, by this information, the Competition Commission was of the opinion that yes, there exists a prima facie case of the infringement of the provisions of the Act, and therefore, it directed the Director General to investigate into the matter and bring up the report within 45 days. So, DG investigated into the case, and they found that yes, there is a cartel like conduct among these respondents, and there are instances of the anti-competitive conduct, because the letters has been issued by the association like the AMPTPP as well as the Producers Guild to the members with an appeal to not to release the films in the multiplexes. They have conducted the several meetings and sent letters to the multiplexes to not to release the movies, and also they have threatened them like of suspension or the boycott if they release any of this movie without their permission. And DG finally found that these behaviors are in contradiction to the subsection 3 of the Competition Act of 2002. So, again from that started the commission's inquiry. So, the commission like basically raised 7 questions like on to which the commission should it should inquire. First, it should raise the question that what was the practice prior to the alleged agreement or understanding in relation to the profit sharing ratio between the producers and the distributor and the multiplex owner. Like how what was the situation earlier, like as I mentioned, now they were demanding 50% of the revenue sharing. So, earlier it was nearly 35 to 45, depends, again it was it varied for different kinds of movie, but now their demand has changed to 50% for all the movies for all the weeks. So, the distribution pattern was quite different between this alleged after this inquiry during this inquiry. Then in the second question was, what is the specific period of the alleged contravention of the section 3 and what manner. So, from what time the alleged contravention have started. So, this complaint has been given around in March 2009. So, it has been continuing till June something. So, it has been quite a year, and as you know, this movie business is a very huge business. So, even a loss of 1 week is very substantial loss. So, that time period should also be taken into account during the investigation. The third question was whether the alleged violator limited or controlled the supply of Hindi films to the multiplex owner, if so, in what manner. So, does like these violate the respondents are the only party who are supplying movies to the multiplex theatres, or what is their basically are the whether the respondents are dominant are in the dominant position or not. So, obviously, because these producers guild and these AMPTTF, like all these are having all the producers and the main, like there are if you look into the report of the commission, which is available in the Competition Commission website of India, you may find all the relevant report regarding this case. I will share the link in the reference section. There you can see they have named all, starting from Amir Khan, Siddharth Roy Kapoor, Mahesh Bhatt, like all they are named, you name all the producers, they were there, Karan Johar, Shahrukh Khan, Red Chilli Entertainments, Amir Khan Production, everyone was allegedly involved in this association. So, they in that investigation, it has been established that yes, they were the nearly main supplier of the Hindi films to the multiplex owners. And during their this period, only one movie has released, that was also a low budget movie which did not do well in the market. And the next question was, What were the specific activities of this UPDF and other association which amounted to cartel like behavior? Like basically here they have found that the various meetings conducted and the simultaneous boycott of the multiplex theatre, of not supplying the movie or issuing letter, etc., fixing the price, etc., are the cartel, etc., were regarded as the cartel like behavior. The fifth question which was inquired was, what is the position after the settlement of the dispute on the point relating to the profit sharing ratio between the distributor and the producers and the multiplex owner, and what is the actual or potential impact on the settlement on the stakeholders. So, what will happen if the price fixing is done? What will be the potential impact on the consumers or the stakeholders? Then the other questions were, what are the relevant factors in view of this provision of section 19 of the Act to establish the appreciable adverse effect on the agreement or the arrangements carried out by the alleged violators, and who were the main violators in the alleged cartel like activity and in what manner. So, all these questions were raised, and these points were basically investigated during this case, for this case. Now, after a complete inquiry, the Competition Commission has found out that yes, this behavior has created entry barriers in the markets for the multiplexes having which is indisputably violated, and because of this price fixing, there is not going to be any benefit to there won't be any benefit to the consumers, nor there are improvement in the distribution of the film or the promotion of the scientific, technical or the economic development in the industry. So, this is basically dealing between the producers and the multiplex owners. So, it is not going to enhance the user's experience or technical experience, or there won't be any economic development per se with the industry. The profit will only go to the producer. The multiplex may charge higher amount, but that is also not so easy. So, now the loss will be from the multiplex owners and the profit will be for the producers or the movie suppliers. So, responding to these things, the respondents said that basically feature film is a part of copyright, is a subject matter of the Copyright Act of 1957, which permits the owner of the copyright to exploit the copyright in any manner as they deem fit. So, basically it should come under the purview of the Copyright Act of 1957, not the Competition Commission of the India. And again the UPDF brought the subsection 5 of section 3, and it claimed that this non-obstante clause excluded such rights from the purview of the Act, and accordingly it was asserted that the UPDF members were within the rights to impose reasonable condition. So, because the films are coming under the purview of the Copyright Act, the UPDF are free to imply any reasonable restriction to enjoy their right. So, this is the contention from the respondent side. Again, so during their contention they have cited many of these cases where they have cited one of the cases, Warner Brothers versus the Santosh VG. So, there by citing with this case, they have they told that as a copyright owner or a film producer can at his sole discretion may determine the manner to communicate his films to the public. This includes the commercial terms on which the film is permitted to be communicated to the public, and so by this case they have said like producer is free to communicate how much money they want to negotiate the amount. So, since the Producers Guild or this UPDF is also a kind of copyright holder, so they are free to negotiate the licensing amount, or the very nature whatever they deem fit for this deal. And also they accused Dizzy of failing to appreciate that a film which is a bundle of copyright is not a good, not per se is not a goods or a service. It is outside the scope of the act. So, they said a movie cannot be considered as a goods or a service which is defined in the Competition Act. It is basically a bundle of copyright. So, and so the Dizzy is erring in his decision. So, all these cases have been cited. and it was further pointed that the DZ has erroneously held that multiplexes are consumers. Basically, they are taking the material from the UPDF as a utilizing those as a consumer, but they submitted that multiplexes are not consumers and they are merely the exhibitors for the film. So, the films are the copyright, they are not goods or services, and the multiplex owners are not consumers. So, in and the section 3.5 subsection 5 of section 3 has provided a blanket immunity to the producers association to use their copyright. So, these are the contention from the respondent side. However, the CCI in his final submission observed that it may be mentioned that the intellectual property laws do not have any absolute overriding effect on the competition law. The extent of non-obstante clause in the subsection 5 of subsection 3 of the Act is not absolutely as clear from the language used therein, and it exempts the right holder from the rigors of competition law only to protect his rights from infringement. It further enables the right holders to impose reasonable condition as may be necessary for protecting such rights, not enjoying the right, and they can place any reasonable restriction to enjoy the monopoly which they can get from the intellectual property rights. So, the CCI gave its observation regarding this section subsection 5 of section 3 regarding the various intellectual property laws. So, this is one of the case where the Competition Commission of India has again emphasized that the IP laws and competition, the IP can come under the purview of Competition Commission of the India, and section 3 subsection 5 does not provide a blanket immunity of blanket immunity from the other sections when it comes to IP related agreements. So, this is so with this the jurisdiction was established, like yes, Competition Commission of India can deal with the cases involving the IP licensing negotiation. We will discuss more cases on how the IP licensing is dealt. So, please stay tuned. Thank you.